It's a great pleasure to be able to be one of Baroness Lister's terriers and to be a signatory to Amendment 13 and to thank her for her conviction, her eloquence and her persistence in bringing this issue back to us again today. It is, as I said at second reading, an opportunity to put right old wrongs, and we shouldn't miss this opportunity yet again. The noble Baroness Lady Mackintosh of Pickering, when she introduced this group, reminded us of her origins and therefore of an interest. And I suppose I should declare to the House as well that I'm the son of an immigrant. My mother was Irish. It was her first language, not English. And she came here at the end of the Second World War, married my father, who was a desert rat and had fought at El Alamein and also seen action at Monte Cassino and elsewhere. But he was brought up in the East End of London, where he saw terrible anti-Semitism, and he and his brothers enlisted in the armed forces because they wanted to contest the fascism that was represented by the Nazis in Germany. And one of them paid with his own price. And I say that simply to illustrate that you don't have to hate one country, Ireland in this case, in order to love another. And I'm very proud of the fact that I have a British and an Irish passport, as do my children and our grandchildren, and I hope that they too will grow up knowing the traditions they come from, but being incredibly proud to be British citizens. In the same spirit that Lady Mackintosh described her origins then, I would also say that as a student, when I went to the great city of Liverpool, I was pretty shocked in my second year when I went out looking for accommodation to see notices in the tobacconist windows advertising accommodation that said, no blacks, no Irish need apply. And I know that the noble Baroness Lady Williams and I have this in common, this shared experience. So it's against that backdrop, and also being a patron of Asylum Link Merseyside and having been involved in these issues over the years in both houses, that I'm particularly keen to support what Lady Lister has said today. Indeed, I was involved in the 1981 proceedings of the House of Commons on the Nationality Act at that time. And it was an attempt, and the noble Lord Dubs will recall this too, that it was an attempt to genuinely try and define what it meant to be British. And it certainly was not part of our proceedings at that time to take away the rights of children to be able to register because of prohibitive costs, debarring them from being able to become citizens. And indeed, I felt so strongly about this that when I was asked if I would provide a witness statement about what I believed to be the considerations that we had had in 1981, I provided that witness statement to the High Court in the action that the noble Baroness Lady Lister has described to us. I also should mention, my lords, that the late Lord Sachs, Jonathan Sachs, in two great books, one, The Home We Build Together, and the other, The Dignity of Difference, I think spelt out the nature of citizenship and why we have to learn to live alongside one another and to value the idea of citizenship. During 20 years or so as the director of the Liverpool John Moores University Foundation for Citizenship, it was an issue I explored, and it was good to see Lady Chakrabarti here today because she was one of our lecturers as part of the Roscoe series of lectures, looking at what it means to be British and how we all should fulfil our individual missions to be good citizens in our society. So, my lords, Lady Lister has told us what the ruling was at the High Court. It's not the fault of the government that this has, as it were, gone to look for further definition at the Supreme Court. But, my lords, why on earth didn't the government accept the decision of the High Court on this specific point about the cost of citizenship for children and leave the other issue, as Lady Lister has said, to be decided about the general parameters? The one doesn't stop the other, and I do think this is something that the House should turn its attention to. The Court of Appeal upheld the High Court ruling that the £1,012 fee for a child to register as a British citizen was unlawful because it was set without consideration of the best interests of children. That's at the heart of this amendment. Two of the judges, I might add, also saw great force in the argument that is continuing at the Supreme Court, that it may be additionally unlawful because it effectively deprives many children of their rights to British citizenship. My lords, It's passing strange that when the noble Baroness, who has been very diligent in responding to questions on this issue, replied to a question that I tabled in the House on the 19th of October 2020, was unable to calculate, or at least the Home Office was unable to calculate, the difference between the £640 it costs to administer the citizenship fee and the £1,012 that it actually charges, even, I might add, to children in care, but couldn't calculate the legal costs of contesting in the High Court the High Court's judgment. So instead of building up even more lawyers' fees and subsidising the immigration system with what Sajid Javid rightly described as huge costs, and this was what the then Home Secretary actually described as these figures, shouldn't we be reviewing that policy from across your Lordship's House? Now, in 2020, there was a widespread view right across all parts of the House. Let me just refer to one or two of the things that were said at that stage. The Lord Bishop of London, the Right Reverend Prelate, said, putting a financial barrier on being able to access one's rights is a clear barrier to one's access to justice. The noble Baroness Lady Alton said that this isn't about immigration, but about children with the right to register as citizens and potentially denying them their right to register if they can't fund more than £1,000. The noble Baroness Lady Primarolo asked whether the Minister would tell the House whether the Home Office carried out a children's best interest assessment of government policy on fees in the light of the original judgment. It's still a question that, as far as I know, remains unanswered. And the noble Lord Paddock asked the government to explain whether they wanted the immigration system to be self-funding in a way that no other government department is. And again, this seems to me to be an unanswered question that I think during the course of these proceedings we really do need to have an answer to. I was struck by what Baroness Garden of Parks, one of the longest-serving members of your Lordship's House, said from the government benches. She asked whether the government have assessed how many people forego registering British citizenship for themselves and their families as they can't afford it. How might this contribute to their sense of belonging and well-being, which she rightly said is important? The noble Lord Kennedy of Southwark asked whether the noble Baroness believed it's right that the immigration system is subsidised by children who are born in Britain and have lived their entire life in Britain and have the right to be British. And I could go on, my lords, but I won't. I think the point surely is now registered with noble lords. We had the chance between now and report not to turn this into yet another contested issue, but there is feeling from across all of the House that we really do need to put right this injustice. This is about putting right an old wrong, and I do hope that the government will attend to it.